Douglas Housman.
Oh, well, this will probably be the first and only time that I'm labeled as distinguished. That's for sure. So this is our first time kind of doing this forum, and we're going to kind of test it out, see what works, what doesn't work. I do anticipate and hope that the fellow attendees will participate, because I think you all have insight and whatnot on various issues, topics, etc., that might be helpful for one another. So the goal is for this to be interactive to the extent that it's possible to be, and we're going to kind of work out the ways in which it's best suited to be interactive. So the rough game plan, outline, whatever you want to call it, is I'm going to talk about the Breslin case and some kind of sub issues that I see, and then I want to kind of open it up for discussion, topics that you've experienced in your practice, maybe questions, whatever it might be with regards to Breslin and anything that comes from that. And then I'll move on secondarily to kind of the pitfalls, the mistakes to avoid when informally helping an individual who may lack capacity, and then we'll do the same kind of process, which is talk about some sub issues and then see if there's anything that we can kind of throw off one another to help our respective practices. So if anyone wants to chime in, with Zoom, I don't know the best way to do that. Maybe put in the comments for now so that we have an idea of what you guys want to talk about, and then when we're done with that kind of section, we can kind of touch on those. Anne, is that reasonable?
Yeah, I was going to say, so if everybody would mute themselves right now, I hear some background from a couple people, I think Mary, Erica, and Dan. And then when you're done, you can just, when we can unmute, you can unmute yourselves and ask questions, and we can change it so it's a group view again, and everybody can chat. So and again, have your questions in the chat. I'm happy to pass those on to Doug if he doesn't catch them, and we'll go from there. See how this rolls.
Oh, we shall, for better or worse. So here we go. Many of you probably already know about the Breslin case, but if you don't, it was recently ruled on. I think it became official in April of 2021. Don't quote me on that. I will be sending, as part of the materials, a copy of the case. Again, it's 6 or 7 pages. It's nothing big, but I did want to discuss kind of the ramifications of this current holding and the what ifs and the unknowns that are associated now with this kind of ruling. So, in essence, the Breslin case allows a probate court to order mandatory mediation. Previously, it was you could recommend it, but you couldn't order it. And the Court of Appeals has recently decided that, specifically under Probate Code 17206, that the court can order mediation to the parties. Now, this, as far as I'm aware, is exclusively dealing with trusts, hence the 17206. So I'm uncertain, as I stand here today, whether this can eventually be or is currently applied to other conservatorships or decedent's estates. But for today's purposes, we're talking specifically in the trust administration context. So, how does this affect things? Well, not only does individuals now are required to attend mediation if the court orders it, but importantly, if you are ordered to mediation and you are notified of that mediation and you fail to go to mediation and there is a settlement reached in mediation and you don't like that settlement, you are waiving your right to object to that settlement. So in Breslin, there was some some errors at law and about 24 charities. There was some type of proposed distribution or some action. 3, I believe, of the 24 charities had objected to the proposed action or proposed distribution, and the court ordered them to mediation. One of the charities notified the all other heirs and whatnot of the mediation. Only a few participated. They reached a settlement. They brought the settlement to the court for approval, and voila, a bunch of the other charities or whatever heirs were unhappy with that settlement. And the court said, sorry, you were notified of the mediation, you did not attend, and as a result, you are waiving your right to object to this settlement. So that's the crux of it. There are some kind of rippling effects that I think are important, and that I am hoping that some of you can provide further insight as well, beyond just kind of my notes. And so I'm just going to go through them real quick. So the first one is, this idea that mediation, not this idea, it was the rule that mediation was voluntary. There's a group of individuals who believe, this Breslin case will kind of take away the essence and the importance of mediation, in that when it was voluntary, people went in with kind of a willingness to attempt to settle. Otherwise, they just didn't go to mediation, right? They were like, yeah, we're too far apart. We don't think it's going to be useful. And those that did go did so voluntarily, and knowing that, they were going to ideally make a good faith effort in trying to resolve their differences. This case takes that kind of idea, or the purity, if you want, away from it, and now forces people into mediation if the court orders it. Now, there's some rippling effects to ordering it. The first one that I see is the financial impact it has on individuals, whether they're actually contesting the terms of the trust or whatever, or they're kind of innocent bystanders, so to speak. I know my experiences with Judge Suyama. He would always, say that, even though I can't order you to mediation, I can order you to the first 2 hours of mediation because those are free. Now that's expanded, and it may force a lot of individuals to have to come up with funds to pay for mediation, because otherwise they waive their right to, whatever the outcome is. So how does this case affect individuals purely on a financial component? If there are individuals who don't have the money, are they being, unduly burdened by having to go to mediation? Does this give an advantage to those who have money? So forth and so on. I'm curious to see kind of what transpires in the various cases, to see if that issue or that kind of sub issue is raised, because I can see it, being a hot topic for, unfairness or whatever, is forcing a litigant to spend money that they would otherwise not be forced to spend. So please kind of add your comments, concerns, ideas with regards to that little kind of subsection. The next one that I'm curious to hear about, and that this court greatly expanded, was the meaning of Probate Code 17206. I've always considered that the kind of the catch-all for discretion with probate judges, and now they've expanded it even further. There's no language in 17206 that specifically says that the probate court can order mediation, but now with this case, it's in essence saying that that's one of the intents. And so, what does what does that allow or not allow for probate courts? It seems to me, in a way that courts can just simply rely on 17206 and say, hey, I'm authorized, or I have the discretionary authority to order you this or not order you that. I think that this is going to be a hotbed area for litigation moving forward as well, is trying to find the confines of what 17206 specifically authorizes or doesn't authorize, for that matter. The court, again, in this holding, specifically references 17206 as the kind of the law in which the courts can make these decisions. And so, what's going to happen? Is our litigants, our practitioners, going to now hang their hat on 17206 when they want something that may not be otherwise, codified in a probate code? Is 17206 going to be the spear or sword that we use to request random things? And vice versa, 17206 going to be a defense mechanism in defending lawsuits or defending the trustee in actions? I don't know. I'm curious. I know there are, even in this Zoom meeting, there are infinitely more individuals who are smarter than me and actually do appeals work and whatnot. So maybe they can enlighten us all with regards to what their anticipated results may or may not be regarding this outcome. The other thing with regards to this holding that I think is very important on a procedural and practicing kind of format is this case specifically says that you have to be notified of the mediation in order to attend, and you choose not to attend and then you waive your rights. If you're not notified of the mediation, my understanding of this ruling is that does not apply to your ability to ultimately object to the settlement. And so with that said, it is important to now send out not only to the actual litigating parties, but all trust beneficiaries and heirs at law, a notice of mediation. And one of the documents that I'm going to send you is a template, and I'm going to try to share my screen and just kind of go over it with you briefly. By no means is this a work of art. I guarantee there are individuals here who have a better version. This is just one that I used in a previous case, and I've tried to redact the information just to give you kind of an outline or understanding of what this, or what a notice to mediation may look like. So let's see if I can do this properly. Ann Wolf, anyone, are you guys seeing that? Shake of the head.
All good. All
okay.
good.
So here's what we got. Blah, blah, blah. Again, as far as I'm aware, this is only for trust matters. Notice to attend mediation, date, time, place, mediator. To the interested parties, their counsel, and the parties who have requested special notice. You might even want to include, all, trust beneficiaries, heirs at law. You can be as detailed as you want with regard to it. Notice is hereby given that the mediation ordered by the court on, I put that in there just because we want to emphasize that the court ordered the mediation, has been scheduled for blah, blah, blah date with mediator, blah, 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 located at whatever. This little paragraph is just because I don't know about you fine folks, but all of my mediations for the last year and a half have been via Zoom, and I do not know when it will not be by Zoom. So we just have this kind of little Zoom kind of notice. If you notice, I earmarked 17206. Again, that's just based off what the judge has ordered. Notice is further given that mediation may result in a settlement, subject to the above referenced case and all interested parties and parties' interests therein. Settlement may result in an agreement. I have these case laws here. You can add them, you cannot add them. Smith case is about attorney's fees agreed upon in a settlement agreement, and the court ultimately ruled in favor that those can be negotiated and whatnot. So again, you can include it or not include it. Again, more notice, given that if you do not have counsel, you can still attend. You may notice that you may be required to pay for cost of mediation. Again, this goes back to this idea that there may be many beneficiaries who don't have the funds necessary to attend mediation. And what is going to happen in those situations? I simply don't know. I'm curious to hear your guys' thoughts. Non-participating persons who receive notice in place may be bound by the terms of any agreement reached without further action by the court or further hearing. Again, this is the essence of Breslin. Here's the rights of intestate heirs, prospective heirs, beneficiaries. Notice is given that all represented parties that intend to participate should advise the mediator, and then you insert the mediator contact information. That is a simple kind of just template there. Again, this will be provided to you all by Ann after the meeting. You can also, do every kind of prophylactic measure you want with regards to sending this by certified mail, adding a service list, doing whatever you can, depending on what party you are within the given action, to ensure that you notified every conceivable human that they can attend mediation. Because what you obviously want to do is avoid the possibility that someone says, oh, well, I was never notified. You have it, certified mail. Now, alternatively, again, depending on, what party you're representing, etc., you may not want to give notice to everyone because you may want to keep that right of someone objecting to the proposed settlement agreement. So this works both ways. If I'm the trustee, and I'm representing the trustee, I probably want to notify every human being possible. If I'm a petitioner who is, swinging the sword, at whomever, I probably want to notify every person possible. Whether I'm, the respondent and I'm in a position of power, all of those variables and factors are important to consider with regards to providing notice. As a general rule, I'm just going to give notice every single time, regardless of who I'm representing and in what capacity. I think it's just a safer bet. But again, I generally represent fiduciaries who are usually acting as a successor trustee role. So many times we're neutral and or impartial. So, we just try to keep a even keel. So how is this ruling gonna, affect us all? Well, we don't know, but it's the current ruling and we have to abide by it. What is the lasting effect of this? That's the $1 million question, because again, I've only pointed out a few areas, but it looks like there's going to be kind of a lot of ambiguity with regards to what happens if I'm ordered to mediation and I simply have no funds. Or what if you have a fee waiver? Does that apply to the mediation costs that were ordered? Again, no idea. You can kind of go, down and down the list, down the rabbit hole with regards to what this ruling may or may not do and how it will affect everyone in the grand scheme of things. So the things I wanted to kind of allow you all to take into consideration is the importance now that everyone, whether you're an innocent bystander, whether you aren't kind of fighting the fight, maybe a sibling is who's lawyered up, maybe there's someone else and you're just kind of having a cursory view, but as practitioners now, we need to advise those individuals who come into our office, that they need to monitor these cases. No longer are they able to kind of sit and wait until their slice of the pie is given to them because they don't have a dog in the fight, so to speak. But now they have to kind of follow these cases, because if mediation is ordered and they don't attend and they were notified to attend, they may lose out. And that's the big issue. So that's kind of my brief discussion with regards to Breslin. Again, the 4 kind of subparts that I talked about that I would love if anyone has insight or discussion is how this affects this idea of the voluntary nature of mediation, how this Breslin case deals with costs associated with mediation. What's your opinions and understandings and discussions, concerns with regards to 17206, and then any ideas, tips, tricks of the trade with regards to notice of mediation. So I've already talked for like 15 minutes, 20 minutes on this. I'm happy to open it up now and see if anyone has questions. Just blurt them out if you want, and we can do a roundtable discussion. Or if everyone's eating lunch and just listening to me, then I can certainly move on. I'll give it a few moments and see if anyone wants to chime in. Otherwise, I'll keep talking. That's never been a problem for me. And I can't hear you.
Nothing in the chat. So maybe
Okay.
just go on, and if things start popping, I'll let you know.
You got it. I'm gonna sip my delicious coffee. Okay. So next, we're gonna move on to kind of what the heck happens when good people try to do the right thing and it goes bad. This is a big picture idea, and there's going to be a lot of hypotheticals, but the idea here is just talking about these scenarios that if someone comes into your office consulting with you regarding what they should or should not do, hopefully you have some insight to advise them accordingly so that we can kind of avoid allegations of elder abuse. So the context here, so that you understand, is mom or dad or both are getting up there in age. They are losing capacity or capacities in question. We're not going to discuss to the full extent that they are completely incapacitated. We're going to talk more in that gray area where a layperson, a family member is starting to see signs of forgetfulness, stuff like that. And family members or friends are attempting to assist informally. So mom or dad or both have, cognitive issues to some degree. They've never been diagnosed. They are being forgetful. And son or daughter, or we'll just say family member of some sort, is helping them. And the real life scenarios that I'm going to use are the following, right? With technology and whatnot. I know my own parents are not very, I guess, internet savvy. They can do certain stuff, but they don't trust the internet. They still, write checks, whatever it might be. So family member, we'll just use myself. I am helping mom and dad in getting auto pay and stuff set up on their bank accounts so that they do not have to worry about it. They don't have to write the checks. They keep forgetting it. We're just going to put auto pay on the mortgage and AT&T or whatever. The other scenario is I have their login information for their online banking, and I am going through each month and paying online again all of their bills or whatnot. And again, the idea is good intentioned. the idea is I'm just assisting mom and dad, and I'm just paying mom and dad's bills and helping them get by. So then that goes on for weeks or months, and there's been no issue. It's kind of been consistent. But there's been periodic times where mom or dad want to go to the ATM and withdraw cash, or they want to go to the bank, withdraw cash for spending money. It doesn't matter. Or they ask you to, transfer some funds to your account because you paid X, Y, and Z when you were out, and they want you to reimburse you. And again, they'll just call you, hey, reimburse yourself for the money you spent. You do it. Again, time goes by, and then sibling finds out. And the scenario here is that you've lived next to or close to mom or dad, and sibling has lived in some other town or county or state for that matter, have not seen the day-to-day kind of activities of mom and dad, have no context or idea that mom or dad have, diminished capacity, and believe now that they got wind of, you cashing money or withdrawing money, and they do you're stealing from mom and dad. So that's and again, there's many iterations of that exact scenario where, something is alleged, and that's all it takes. The allegation of wrongdoing. And mom or dad, or let's say siblings don't like each other for whatever reason. And, this other sibling is going to take it to their brother or sister because, shocker, this is a power position. So brother or sister lawyers up and makes a claim or an allegation that you have been financially elder abusing mother or father. And they're able to get the statements that show these cash withdrawals. And you're, because of cash, you can't really prove it, what they were for, nor were you ever, ready for that because you were never advised what to do and what not to do. And last, there's some type of, petition filed, elder abuse, whatever it might be. There's a conservatorship filed because mom or dad didn't have a power of attorney or advanced healthcare directive. And again, you get involved because you want to be the conservator, and then someone else does, so forth and so on, and it blows up. So there you go. That's the scenario that we're going to talk about. And again, there's many iterations of it. So what happens, or what would happen should, a client in this scenario come to you? Well, the first, and I think the most obvious, is find out if mom or dad does indeed have sufficient capacity. I always advise these individuals, don't do anything. Don't help them, as bad as that sounds. And the reason is because all it takes is a sibling or a family member to make an allegation, and then all of a sudden, for all the good things you may have done or intended, the narrative has changed for you, and now you're on the defensive saying, no, I did this because mom wanted to. Well, mom can't speak now, or dad can't speak now to clarify. So do it the right way, right? That's going to be our natural, organic response. Hey, see if mom or dad can execute that, execute an advanced healthcare directive or power of attorney. How do you do that? Well, for me, number one, if the child comes in, I am not going to be meeting with mom or dad. I'm going to have mom or dad go to their own attorney or some independent attorney. I'm not even going to refer them to an attorney because I don't want it to come back to think that my client influenced in some form or fashion mom or dad's decision to go to an attorney. So presuming that they have capacity and whatnot, and they do in fact go to an attorney's office to get an advanced healthcare directive and power of attorney done, and that attorney does the normal kind of measures. They cognitively are clear, whether it's a doctor's note or whatnot. They have all these things going in place. So if that's the case, then you get them done. It's golden. problem solved. You have an advanced healthcare directive, you have a power of attorney, and whenever they actually are deemed incapacitated based off those documents, then your client now can act. The other scenario is they don't have capacity, or a doctor is unwilling to, or some other attorney, however many attorneys they went to, are unwilling to draft those documents for them. Well, that's that kind of tough conversation you have with your client where you say, I don't think you should be doing this informally. I think a conservatorship is necessary, and it's the safest way, though it may be expensive. It's most individuals, nod their head, say, yes, thank you for telling me that, but never proceed with it. Because again, depending on the, financial situation, mom or dad may not have the money, and son or daughter may not have the money to pay for that. And maybe the son or daughter is concerned that when they do go forward with, a conservatorship, that other sibling is going to contest it. And they prefer to just avoid the drama now and just continue to do things informally. Again, that's going to lead to bad news, because all you're ultimately doing is delaying the inevitable. In essence, okay, you can at least get ahead of the game, be in control of the narrative, advise the court what you're trying to do, and let sibling object to or not object to, versus not doing anything. And then when sibling potentially finds out, they bring an action not only for conservatorship, but also to say that you abused mom or dad. Again, it's always the client's choice, but I'm not a fan of it. I try to get ahead of things and try to control the narrative. I think that's the key in most scenarios. So if the client chooses to go forward with that, then you have your typical conservatorship action, so forth and so on. More often than not, like I said, they choose not to. And what happens then is sometimes you never hear from them again because everything just worked out great. But more often than not, I find that they call me in some form or fashion down the road saying, hey, the bank, flagged something and they won't release it now because mom or dad have diminished even further with their cognitive decline. And now they are incapable of signing or doing anything. The question I always ask is, well, when do you believe that actually occurred? A month ago, a week ago, a day ago? Whatever the response is, I always ask, well, is there a doctor's determination? Did the primary care physician or a neuropsych have determined that they lack capacity? And if so, when did they lack capacity? That's the next question. Okay, so now we have a starting point. The next question is, are any siblings or family members or friends concerned? Are they going to bring any action against you if they're even aware of, the activities that you've done? Or alternatively, are you kind of in the clear, or is everyone on the same page? Again, more often than not, people aren't coming to your office because everyone's on the same page. Sometimes, hey, we've collectively decided something and this is what we want to do, and we have everyone, on the same page. Wonderful. But more often than not, they're coming to your office is because they have questions or concerns and are worried potentially that they may be personally liable in some form or fashion, or because some sibling or family member is sniffing around and is asking questions or being accusatory, and now this individual is getting defensive. So what to do, how to do it, and when to do it are the main three questions you're going to be advising these individuals should they walk into your office. And the first thing you should be saying is, don't do anything informally. Don't do it. Don't do it. Better safe than sorry. I get what's going on, but mom or dad needs their own attorney. I'm not going to give you a referral. Just see if mom or dad, because then at least you have a buffer. Hey, mom or dad went to attorney. He or she advised mom or dad. They executed whatever they needed to. You're at least covered. If they don't say anything otherwise, or aren't agreeable to that, or it's too much work to get mom or dad because they're they don't trust attorneys or whatever, then you tell them, don't do anything. Let mom or dad, try to figure it out themselves, or at least, have mom or dad do it the old fashioned way. Maybe you give them friendly reminders, but don't actually do the transaction yourself. Because the biggest thing that's going to happen, and that I see in my own practice, is an allegation comes out and the at issue is, we'll just say $20,000 of, cash withdrawals or teller withdrawals over a 1-year period, we'll just say. And the litigation involved far exceeds the amount at issue. And what happens is, your bill is 25,000 and the opposing counsel is 20, and all of a sudden, these bills are double or triple the amount at issue, and the parents ultimately lose, right? There's no kind of happy medium where, the two sides go, hey, let's take a time out here. Our bills are getting so high that, we should settle this. Most attorneys are simply advocating for their client, but that's, one of these rippling effects, one of these side effects of doing things informally. The other thing is, what's the cost of getting an advanced healthcare directive and or power of attorney if mom or dad has capacity versus the litigation side? $1,000, $500. I don't know how all other practitioners are, but depending, we have a template for the most part with regards to what our standard power of attorney or advanced healthcare directive is. Maybe we have to make some tweaks one way or the other, but otherwise, it's not all that time consuming. And so, dealing with another generation who may or may not have gone through, the Depression era or whatever with regards to funds, and they are frugal and rightfully so, and are afraid of attorneys or whatever it might be. You really got to hit home the cost benefit analysis with regards to doing this the right way. I know even for me, most of the time I'll just charge halftime because I usually like the human being. And, I'm like, hey, here you go. This is going to help you down the road. If they don't, you can't force people to do the right thing. But I know for me, when individuals come back to my office and are, hey, what you predicted happened, I say, well, now you have to pay me with your own money. This can't come from mom or dad because there's allegations against you. And they say, well, why can't this? And I'm like, well, because, they're alleging you are abusing mom or dad financially. And if you use mom or dad's money to pay for your attorney, that's only going to add fuel to the fire to the argument that, you're financially abusing mom. And it's against the rules to use, mom or dad's funds to defend your actions, unless you are in some form of formal capacity, such as successor trustee. And even then, there's a gray area with regards to whether you can use funds to defend a breach or not. So what I would want in this scenario, and if people are, willing and are able to discuss, stories or similar circumstances or what came of it in their own practice, whether they have any suggestions on how to resolve these things before they occur, if they have any handouts that they give to potential clients. I used to have a handout that was, and I couldn't find it. I wanted to provide it for this presentation, but I used to have like a what not to do and a checklist that I would give to these type of clients and say, hey, here's some things to take into consideration. Because then I could say, hey, here's a copy of it. This is, these are reference points and whatnot for people, and best of luck. So does anyone here in this forum have any thoughts, stories, ideas, etc., that they might want to, give to the group? All right.
Hello?
Hello? Anyone? All right, that's fair.
I was gonna start talking about his recycling unless you guys, you know.
I know. I mean, hey, this is the first one. So
Here we
you know,
go.
we obviously
you,
have a very
Svetlana.
talkative group. So
Got one question. Thank you, Svetlana. Why do we think the executing of a DPOA and an AHCD would prevent those family members from bringing an elder abuse case?
well, my 2 cents is, you can never stop someone from bringing an elder abuse case. I mean, whether you do it right or wrong, or don't do it at all, people are going to make the allegations. But what, you know, the grand scheme of things is you have a second set of eyes, potentially the drafting attorney, whoever did the advanced healthcare directive and the power of attorney, and hopefully he or she went through the normal steps, you know, or the advanced steps of getting a, you know, capacity declaration or whatever from doctors, so that, you know, if the allegation comes, you have documentary proof to suggest otherwise. Anyone else? Or
Dan Maloney. Please comment on the not paying for legal defense for breach from mom, dad's funds. Is that the attorney accepting the funds could be disgorged?
say that again. Sorry, you broke up there slightly on me.
It's in the chat too. So comment on the not paying for legal defense for breach from mom, dad's funds. Is that the attorney accepting the funds could be disgorged? Is it that the attorney accepting the funds could be disgorged?
Gotcha. So on my chat function, I only have three things from you, Ann. So just so you know. So
they're sending them just to me. Okay.
Okay.
You guys can send them to everybody. You can do it everyone.
Yeah. So I mean, so Dan, to answer your kind of question or comment, like, it's very gray for me, and if it's gray for me, I don't want to. I want to avoid the view that I may be using mom or dad's funds to defend the individual who may or may not have financially abused. So Dan, in this case, you represent the sibling who is suing my client for financial elder abuse, alleging, amongst other things, that my client had withdrawn via ATM and teller $20,000. And when you do that, you know, my client comes to me and says, Doug, you know, my sister or my brother is suing me, and this guy named Dan Maloney is suing me. And I say, hey, well, you know, I'm going to need, you know, a retainer. And they say, well, can I use mom or dad's funds I still have access to? Well, I mean, therein lies the problem. If my client is not in some form of capacity, a power of attorney or advanced healthcare directive, then they're not his funds, right? He can't use those funds to pay for his attorney. He would have to use his funds. But if he is in some form or fashion a power of attorney or advanced healthcare directive, then the question is, well, perhaps, right? Because depending on, you know, the elder abuse, you know, allegations, they're likely going to say that he either, mom or dad, didn't have capacity to execute these things, this power of attorney, this advanced healthcare directive is invalid, or you, while acting in that capacity, had breached your, you know, fiduciary obligations, et cetera, by withdrawing money. So again, you fall into this trap of, if I say, hey, use mom or dad's money to pay my retainer, and the opposing attorney finds out about it, they, in all likelihood, may use that as further proof that my client is financially abusing, you know, their client. Now,
so Dan follows up and says, some attorneys accept the funds anyway. How do I stop my abusing sibling from paying his attorney with mom, dad's funds?
So in most of my petitions that I file, when it's like, you know, I'm trying to remove a trustee, or if I'm doing a probate code 4000, like power of attorney, you know, removal or something of that effect, I always ask that the power of attorney funds or the trustee may not use trustee funds to pay their attorney. Always. It's one of the causes of actions that or the prayers that I always put in there. So, and then what I do is at the very first hearing, I ask, the judge or whatever to simply rule on that one issue while everything else, gets kicked down the road, whether it's mediation or blah, blah, blah. So you got to ask for it. And, depending on the facts of the case and, the degree of, actual financial abuse, you may, have a good argument or a bad argument. I have a case right now, and I kid you not, it's a Solano case, but there's, 10 kids or whatever it is. And this guy out of the blue, in the last 6 months of mom's life, had her go to an attorney. He's not related in any way, shape, or form. And he became the trustee and sole beneficiary of her entire trust. And, he, is this not related, not a friend, not just a human being who just happened to meet mom. So in that, I filed a complaint, and the first thing I asked for is that, this is a rare or a unique circumstance. It's not like it's one of the siblings who is, the successor trustee. This person had no prior relationship, and, they should not use mom's, trust funds to defend themselves because there's clear undue influence, et cetera, et cetera. So it's, you ask for it, and hopefully there is, you get your way. Again, a lot of times I found that judges like to not allow the trustee to use trust funds because it forces settlement sooner.
So Dan says, have you ever gotten a ruling on that issue before the case moves forward? I haven't. Do you have an evidentiary hearing?
No, I've got it granted in Judge George's department by just simply asking. I just, said, hey, moving forward, can we get an interim order that says that the trustee cannot use trust funds to pay their attorney? But what I like to do to make it kind of more not as a litigant is, but Your Honor has the authority to at a later date, at an evidentiary hearing or whatever this is resolved, to kind of retroactively look back and see if these funds can ultimately be used. So it gives the judge an out, it gives the other side an out, but it also gives me the order that I want presently. So I don't know. Sometimes I get it. Sometimes the judge hasn't read anything and just kicks everything down the road. But I'm always looking for that specific prayer first while we work out everything else.
So Doug, in the chat, and I think you can see this one, Svetlana asked how to avoid allegations if mom and dad ask you to find a lawyer to draft estate planning documents. And then Rita responded, you could have a psychiatrist evaluate mom and dad as to the capacity before you draft the documents. Mom and dad should pay for the evaluation. You want to comment on that? That's good.
There is a lot of things. First rule of law for me is everyone lies, prove it to me in documentation, right? So mom and dad told me, no, you're lying, prove it to me in documentation. Have mom and dad write you a letter in their own handwriting. Don't necessarily do an email, because that can be, that can just be, oh, you did it and you just, did it from mom's email. Have mom or dad write you a letter or whatever saying, hey, do you think you can, look for some attorneys for me? And then document everything. I would email like 3 different attorneys and say, hello, I'm inquiring on behalf of my mom and dad. Attached here is a letter from my mom asking that I, look for attorneys. Would you be interested? And if so, I will have my mom and dad contact you. And that's the way. I would not drive mom or dad to the lawyers. I would stay as far separated from it as possible, have a friend do it, have a third party credible individual do it. I would also, have a mom's primary care physician do a letter. If you want, if you want to go to the, you know, big dogs and get a neuropsych report or a psychological evaluation and give that to the lawyer? Absolutely. If mom or dad is coming to me to draft something like that, I'm doing a number of things if I visually see or hear that I believe that they have, you know, diminished capacity. I'm saying, hey, number one, I need a doctor's note. If you have it already, great. Number two, I'm slowing the process down, right? Depending on what they weigh. If they're trying to disinherit a child and make a trust, I'm slowing it down. If they're trying to do an advanced healthcare directive and a power of attorney, I have no problem with that. Number three, I'm gonna tell them to get another evaluation after they sign the documents, so that you have it both before and after the execution of the documents, right? And then I'm gonna, you know, document everything. I'm just gonna paper. I'm gonna do CYA letters. I'm gonna do the whole shebang. So as a child doing this, document everything. You know, you win most of your cases, or you stop most litigations by documentary evidence, one way or the other. That's it.
So Carolyn wanted to know, have you ever declined to draft estate planning documents? Can you explain the circumstances and why?
Yeah, a number of times, and a number of gnarly ones too. So I got contacted by a elderly lady telephonically who wanted me to, you know, review her estate plan and, you know, meet with them to amend it. And so I was like, sure, you know, I talked to her on the phone. I asked if she was, you know, competent with email and whatnot to send me versions of it. She was. She scanned the documents, emailed them to me so that I could review them before meeting with her. And then we set a time to meet. So they show up, her and her husband. Number one, her husband was clearly incapacitated. Clearly, I mean, like almost, I mean, and not being, you know, but like leaning over, drooling, getting wheeled in by a, you know, wheelchair. And there was two other individuals, and they came into the conference room with me, and right off the bat, I was like, you know, who are you? And they're like, oh, we're just family friends from church. So I spoke with the client. I reviewed the trust documents. I realized that, you know, that this individual, that the trust required both settlers to amend what in their joint lifetimes. So I advised her that we can amend one portion of the trust because she realized that he was already incapacitated. He had a letter of incapacity. So we kind of did the allocation and whatnot. We started amending that and slow it down a little bit. I get phone calls from her saying she wants to include other individuals and disinherit individuals. And in large part, it was these two individuals that showed up. So I had her come to my office again. These two individuals accompanied her this time. I talked to her in person. I asked her straight up, are these people influencing you? Who are they? Blah, blah, blah. She was adamant that, you know, that these people were just friends and I want to take care of them. I then said, I'm uncomfortable with it. I think they're unduly influencing you. I think you're opening up a slew of litigation because your biological children are going to sue these people when you pass away. And I don't have the time or effort to be called as a witness to this. That was one scenario. We had started the process of working together, and then I just cut it off. Another one is mom walked in with son. I spoke to them both together at first. Son was really kind of answering for mom. When I asked mom the simple kind of questions, you know, just, you know, shooting time, hey, how you doing? Little things like that. I could clearly see she couldn't answer. And then when I had the son leave, I spoke to mom alone. She couldn't answer my questions. And then I had son come back in and said, under these circumstances, I'm unwilling to, you know, draft this stuff. It's uncomfortable, but it's necessary.
Excellent. Okay, so if you haven't, a couple of people haven't done the poll yet, quick do that because I'm going to end it, and you need it for your if you're interested in MCLE credit. So, okay, one more, anybody?
The last thing I want to say is if someone like this comes into your office, take detailed written notes. Just
I am
handwritten
not-
notes.
Where is the, where, I don't see the quiz or whatever it is.
Rita, I already took it down, so I'll note that you were there.
I never saw it. Was it in the chat?
No, it pops up on your screen. If you're on your phone, it won't work.
Oh, okay. All right.
All right, y'all. I am 100% certain that you guys all are tired of hearing my pretty voice. So I'm gonna let Ann take it away. Thank you all for participating. I'm sure you guys were all eating your lunch, enjoying the good times. I'm gonna go eat mine. But I am curious if you guys want, shoot me an email with regards to any thoughts with regards to Breslin case and or, you know, informally assisting. I'm always open to hearing other people's approaches because I think collectively we work better when we, you know, throw ideas off each other. So thanks.
Oh, we got people chiming in now, but we're good to go though. So thanks, Carolyn, for your follow-up. And Mike Buslick thinks Breslin needs a legislative amendment to 17.
Oh, it most certainly does. But those are the smart people, not me. But yeah, 100%. There's going to have to be some type of, you know, clarification or.
Yeah, not my job. Okay. All right, everyone. Well, thanks so much. We're gonna have another one of these is coming up. Oh darn, I can't remember.
Oh, it's what, the June 15th, something?
Oh, hold on. I can tell you really quick. I should know this, but there's just so many things. Hold on. The next one's gonna be June 15th, civility and conservatorships. And I believe that's with our friend, is that Catherine Schofield?
No, Catherine Korn, I thought.
Nope, Catherine Schofield.
Let's go. My apologies.
So anyway, so there'll be a presentation, but it's also meant if you have questions, and it doesn't have to be on the particular topic. It can be in general if there's something going on and you have a question and you want to put it to your
colleagues,
practice mates here. So it's meant to be a little bit of a discussion at the end here. So, okay, everybody good?
Awesome.